do not require a new trial to be ordered for the appellants.
I ask Christ him for free today.
The judges have made their decision whether Kartel should be released or face a retrial. You know what? Let's jet into this story. Welcome to Jet. So first and foremost, before we get into how the judges reached their decision, give thanks to Yahweh and Yahushua. Yes, man. Today is a good day for Vybz Kartel and his co-accused because the judges have ruled that he should be freed and a retrial is not ordered. Jet had been consistent that after the conviction had been quashed, they should have released them pending a retrial hearing, and Jet was correct because to some extent their constitutional rights have been breached, which formed part of the judge's ruling. If you don't believe me, look at his previous videos on the topic on the channel. Justice Mrs. Marva McDonald Bishop gave her reason for the unanimous decision. Watch this.
A team of police officers went to the Swallowfield premises to investigate the alleged homicide. They noticed that the house smelled of disinfectant. When the police returned to the premises on a subsequent visit, they found that the entire interior of the house had been destroyed by a fire. On a further police visit, it was discovered that the rear of the house had been demolished. The police dug at the premises but did not find anything of significance to their investigation. Away. The trial judge and counsel on both sides questioned the forewoman of the jury in chambers. The forewoman informed them that Juror X had spoken to all the jurors and encouraged them to free the appellants without regard to the evidence. There was no evidence to connect any of the appellants with the activities of Juror X. Faced with the possibility of having to abort the trial judge heard submissions from the Director of Public Prosecutions, the DPP, and Defense Counsel. Despite Defense Counsel's resistance, the trial judge decided to continue with the summing up and handed the case over to the jury that evening.
The trial judge continued with the case despite the tainted juror, and the prosecution failed to put a good case as mentioned in previous videos.
The jury deliberated for over 3 hours and by a majority of 10-1, convicted the appellants of the deceased murder on the same day. The appellants were each sentenced by the trial judge to imprisonment for life at hard labor, with the stipulation that the appellants Campbell and Jones should serve a minimum of 25 years in prison before becoming eligible for parole, and the appellants Palmer and St. John should serve a minimum of 35 and 30 years, respectively. The appellants were unsuccessful in their appeal to this court and appealed to the Privy Council. The Privy Council allowed the appellants' appeal and quashed their convictions on the basis that the trial judge's treatment of the third incident of jury misconduct was a material irregularity in the course of the trial, giving rise to a miscarriage of justice. In the Privy Council's view, the trial judge should have done more to investigate the third incident of jury misconduct and not rely solely on the forewoman's account. Furthermore, allowing Juror X to continue to serve on the jury was fatal to the safety of the convictions and was an infringement of the appellant's fundamental right to a fair hearing by an independent and impartial court under Section 16 of the Constitution of Jamaica. Lastly, the fact that the prosecution was prepared to waive the irregularities in the trial did not absolve the trial judge of his responsibility to ensure a fair trial. In all the circumstances, the trial judge ought to have discharged the jury and ended the trial in order to protect the integrity of the system of trial by jury. He ordered to face a new trial, or whether judgments and verdicts of acquittal should be entered. The court starts with the Constitution, which provides that upon conviction, a person should not be tried for a second time unless a court of superior jurisdiction, which is the appellate court, orders that there be a retrial. The Constitution did not set out the circumstances in which the court should order a retrial. It is to case law that the court looks to determine trial. The principles governing the question of a new trial, which was set out more Privy Council in the case of Reed against the Queen. We will not state 20 cases since Reed, and we have an amalgamated list of those factors. There are 12 factors that the court has considered. The seriousness and prevalence of the offense, that's one. 2, the strength of the prosecution's case. 3, the availability of the prosecution's witnesses and exhibits. The fairness of a new trial, if ordered. 9, 11, potential legislative changes in the sentence for murder. 12, the possibility of prejudice arising from the mandatory minimum sentence and minimum term before eligibility for parole. We have considered all the factors governing the court's determination of whether a new trial should be ordered, and have given due regard to all the material, submissions, and evidence presented by the appellants and the Crown. We commence by stating that the egregious nature and seriousness of the offense in this case is beyond argument. So too is the prevalence of the offense of murder in Jamaica. We make a barefaced defiance of law and order involving allegation recovered, or should we say an alleged killing in which the body of the deceased has not been recovered, and interference with the role of the police. The court is therefore satisfied that the nature, seriousness, and prevalence of the alleged offense in this case, that there are several equally powerful factors which, when combined, militate against ordering a new trial.
It is a sad day for some and a happy day for others.
In summary, these factors are the insufficient and inadequate account by the prosecution for the availability of its witnesses and trial exhibits, are now unavailable or cannot be accounted for.
The prosecution had years to ensure that if the case is to be retried while defending the appeal at the Privy Council, together all the relevant evidence and witnesses should the Privy Council send the case back as it did. Yes, man, the DPP office messed up the case. We wonder if Paula would have done a better job. But she had just been constitutionally removed, and she is not without blame.
3, the 64 days and utilize a significant share of the court and the appellant's resources. Therefore, the time, financial costs, expense, and impact on the court's resources, as well as getting trial, we find that this is significant and it militates medical effect that a new trial would likely have on the appellants who have already spent 13 years in custody with problems relating to the appellant Palmer, which came through medical reports that stand unchallenged by the Crown and therefore speak to declining health in the penal institution. The court looks at the lapse of time, estimation be at least 15 years. We find that to be inordinate. 6, the unjustifiable interference with the appellant's constitutional rights, Section 16 of the Constitution of Jamaica, and the potential for that breach or interference, we should say continuing, if a new trial is ordered. We look at the potential prejudice to at least 2 more eligibility for parole than that which was originally imposed upon them after their first trial due to the operation of the statutory mandatory minimum for the offense of murder.
Well, the judges considered the then accused constitutional rights over the victim rights, it appears. It looks as the case developed that this case was bound to fail based on the incompetent performances by the DPP's office.
The court looks at other factors which it did not see swinging the pendulum either way. Publicity did not assist the appellants. We find that pretrial publicity is such that you would have to prove that it is impossible to obtain a fair trial. And that question is one for the issue of pretrial publicity is if the mechanisms have to be employed as the Crown had argued, that would add to the delay of the proceedings. As we have said, we have looked at all the other factors, but we find by now the countervailing, the weight is against a new trial.
Nice again and be a class power vote again. Big up the vibes. I will get a new class. I be a class. I be the come on.
Having regard to all the considerations the court has taken into account, we conclude that the interests of justice do not require a new trial to be ordered for the appellants, and we therefore make the following order. Judgments and verdicts of acquittal
Vybz Kartel, freedom. We tell them. Jamaica happy now. Jamaica happy now.
One Gaza, a data farmer responsibility. One DJ, one vibes.
God is good.
Lion. One son,
And the
Gaza,
children
son,
them
a data farmer.
love him.
Lion.
And a little bit him doing ya. Him do a lot for we.
We're nice
God
again.
is good.
We're
All the
nice
time.
again. We're not Selassie. We're not broke, we're not hungry again, we're nice again, and be a class power vote again. Big up the vibes. I will get a new class. I be a class, I be the come on, I be a sitting. My belly full again. Be a straight jeans and fit it again. Remember that.
No matter what, we should respect the court's decision. Unless the DPP decides to launch an appeal, which I don't think they will, Jamaica will be facing a hefty lawsuit running into the billions for false imprisonment and loss of earnings. Kartel is now a free man, and we should all respect that. Yes, man. So, what is your view? Do you believe justice is served? The victim is denied justice, or the prosecutor messed up the case and incompetent? Write your comments below, man, and let's have a discussion about this. For those of you who've forgotten to subscribe, please touch the like button, smash the subscribe button, and touch up the bell. And remember to share with your friends and family. So here we are going now. We are gonna jet off, you know.